So we have chapter 1, the legal framework affecting public schools. The Bill of Rights represents the primary source of individual rights and freedoms under the U.S. Constitution. The first 10 amendments is the Bill of Rights, and it's the fundamental liberties. That's where you get the freedom of speech, freedom of press, freedom of religion. The main ones that are talked about in this one are going to be the freedom of speech and freedom of religion in this entire chapter.
These restrictions simply mean that the government cannot exercise certain powers in relationship to free people. So basically, the government cannot pass certain laws to take away the freedom of speech of the people.
So the federal constitution, the Constitution of the United States is the basic law of our land, and it provides a framework for the law, which order our governmental processes, and it applies to us in education because it helps us provides us with board policies.
So all statutes enacted at the federal, state, and local levels, as well as the state constitutions and local regulations and ordinances, are subordinate to this Constitution, which means the U.S. Constitution comes first, and then the state statutes have to fill in the gaps of anything that the Constitution does not address. So the federal Constitution is distinguishable in its provisions to protect fundamental rights of all citizens of the United States.
So along with these rights, the Constitution doesn't exactly reference to education, but overall it does have an impact on what we do in the management of our schools and making sure that students, faculty, and staff all have the rights that they need.
State Constitution, based on the 10th Amendment of the Federal Constitution, powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively.
So state constitutions represent the basic source of law for individual states and generally require legislative bodies to perform various functions, including establishing systems of public education. They prescribe funding and operational schemes for public schools. So this is where we get where we'll discuss later is the states are mainly in charge of our educational systems with some federal oversight, but our states are in main control.
Going along with that, the state constitutions have to cover what the federal constitution says, but they cannot fail to meet the basic requirements of what the Constitution is telling us.
And that's where the statutes come in. Statutes represent an act of the legislative branch of government. Statutes are the most abundant source of law affecting our public schools. And schools' district policies, rule, and regulations are generally based on statutory law.
So statutes represent the most effective means of developing new law or changing old laws. State legislators grant local school boards the authority to adopt and enforce reasonable rules and regulations necessary for the operation and management of schools.
Court or case law. So case law is generally reflected in judge-made or common law, which is distinguished from the statutory law. And basically, this talks about how the decisions that are made, people will use these decisions, and other people will be able to see how these decisions affect other decisions made.
State boards of education. These state boards of education are administrative agencies created by the state legislature. They determine to some degree the direction of education in the state. Public schools are placed under the control of state boards of education.
State boards may develop policies covering areas such as health and safety, teacher license requirements, graduation requirements, and others that are relevant to the educational needs of their state. So one of these that I've had to, or my buddies have dealt with is like teaching in South Dakota, you have to have certain classes. You have to take a Native Americans class, I believe, in order to teach in the state of South Dakota. So when my buddy went from Wayne State College to South Dakota, he had to take another class. So that would go under the state boards developing their policies for teacher licensing.
Underneath the state boards, you have the local school board, and these school boards impact like education policy, the administration. They supervise what's happening within their district. And although their roles still do have to align with the state statute.
And these policies may be accompanied by rules and regulations that provide direction for operations of schools.
The U.S. system of courts, the judicial system consists of federal and state courts. The organization of the courts at both levels is essentially the same: trial courts, intermediate courts of appeal, and the highest court, the Supreme Court. So that goes up through the state Supreme Court, and then it will move on through the federal courts.
The federal courts deals with all issues involving our entire country. So anything that is a constitutional issue, and it goes through the 3 different levels. I think there is the district courts, the Court of Appeals, and then the Supreme Court.
There's 95 federal district courts in the United States, but there's in bigger states they have more. For example, New York and California have 4 federal courts.
Federal courts usually hear cases between citizens of different states and cases involving litigation of federal statutes. Federal appellate courts are represented by circuit courts of appeal.
There are 13 federal circuit courts, including 11 with geographic jurisdiction over a number of states and territories, 1 for the District of Columbia, and another involves 3 specialized federal courts.
The primary function of appellate court is to review the proceedings of lower courts to determine if there's errors, and as opposed to facts. There's regulations, constitutional misinterpretations, or inappropriate application of rules and evidence. Sorry, I got a little nervous.
So the state courts are part of each state's judicial system with the responsibility of hearing cases involving issues related to the state constitution, state constitutional law, state statutes, and common law. So this is mainly where we deal with a lot of the educational law that deals with things put down by the state because of that being a state mandated thing. Many education cases are heard in the state courts because they do not involve a federal question.
Courts of general jurisdiction. So these are the ones where you see all different kinds of cases. They are often referred to as district or circuit courts. Their jurisdiction covers most cases, like I said before, except those that are held for special courts. And in many instances, decisions may be appealed from these courts to intermediate appellate courts or even to the state Supreme Court.
Courts of special jurisdiction, these are established to hear legal disputes in special matters, like referrals to a trial court with limited jurisdiction, and may be called municipal justice of the peace or probate small claims, and traffic courts.
Intermediate appellate courts. Intermediate appellate courts have emerged over the past 3 decades to hear appeals from trial courts or certain state agencies. Their primary role involves reviewing proceedings from trial courts to determine if substantive or procedural errors occurred in applying the law.
The Supreme Court. The Supreme Court is the highest court in the land, and unlike lower courts, there is no appeal beyond the decision of this court. The Supreme Court's ruling can only be overturned by an amendment to the federal Constitution.
9 justices, including a chief justice, comprise the High Court. To avoid political infringement, they are appointed to life terms. Cases reach the Supreme Court primarily in two ways: an appeal and by writ of what is that? Certiorari? I don't know what that one is.
I think that's right. I think that's the last one. The main one in the Supreme Court that I was looking at when we were reading is making sure, like, when they talked about the Supreme Court decided, like, those are done for. Like, that is what we go by when we're trying to make our decisions, especially as principals and educational leaders, is making sure that the Supreme Court rulings are not going to change. So we better have a good understanding of those. And then we are updating ourselves on state statutes and stuff like that. You guys have anything else to add?